Good afternoon, everyone, and welcome to today's Regulatory Transparency Project webinar titled, Does Privacy Exist in an AI World? This is part one of the discussion, Rethinking Data Protection. We're so glad that you're able to join us today. My name is Libby Dickinson, and I am the Assistant Director with the Federalist Society's Regulatory Transparency Project. As a reminder, all opinions expressed are those of the speakers and not of the Federalist Society. We're honored to be joined today by a fantastic panel of legal experts addressing the questions surrounding AI policy and the effect on consumer data privacy. After the panel discussion, there will be a short period designated for audience questions. We ask that you submit them via Zoom's Q&A feature, not the chat, and that they are pertinent to the topic at hand. In order to get right to the discussion, I'll start by briefly introducing each panelist and then hand things over to our moderator to start the conversation. Our panel today includes Pam Dixon, the founder and executive director of the World Privacy Forum, Kevin Frazier, AI Innovation and Law Fellow at the University of Texas School of Law, and Jennifer Huddleston, Senior Fellow of Technology Policy at the Cato Institute. Our moderator today is Ashley Baker, Executive Director with the Committee for Justice. You can find out more about today's moderator and panelists at fedsoc.org. That is fedsoc.org. With that, I will hand things off to Ashley to get us started. Ashley, thank you so much for joining us today.
Thank you, Libby, and thank you for hosting this. It's a very timely topic. We couldn't have a tech policy discussion without AI this year, it seems. So I'm going to start off the panel with kind of just a broad general question for each of the panelists. It's been a couple of minutes on what do you kind of see as being the state of affairs right now in AI and privacy? I know that's a very broad 30,000-foot question, but what exactly are the issues that you're focusing on, so we can each kind of narrow it down a little bit?
Yeah, happy to jump in here. First, Ashley, thanks so much for moderating. Libby, thank you so much to you and the Regulatory Transparency Project for hosting. It's great to be included among some esteemed panelists, including Pam and Jennifer. So thanks for this opportunity. From my vantage point here in Austin, I think that we are in the equivalent of 1908 when it comes to AI. So 1908 was when the Model T was first introduced. And if I were to ask you who's going to win in a race, someone driving a Model T or someone riding a horse, the answer would probably be the horse. And the reason why is we didn't have the rules, we didn't have the norms, we didn't have the know-how to make sure we were using cars to their full advantage. And as a result of that, legal infrastructure, social infrastructure, and just cultural surroundings, we weren't maximizing the benefits of that technology because we were relying on the roads and the norms of a bygone era. Well, obviously, fast forward now, and I think most folks would say they would opt for their Cybertruck or their Prius or whatever car over that horse because we built that infrastructure out. In the same way, I think when you look at the state of AI in 2025, we still haven't built the roads, we still haven't built the street lights and the stop signs for figuring out how best to use this technology. And that's particularly true when it comes to privacy law. All the things we know about how AI works and how AI works well really kind of conflicts with the best practices when it comes to thinking about privacy law. The best practices that were developed in the 1970s are things like limiting data collection, things like limiting data sharing, things like making sure we have specified use cases before the data is collected and making sure we delete that information as soon as possible. And yet, for AI to do well and for AI to do well in very specific contexts, we need as much data as possible. We need to hold on to that data for as long as possible. And we need to continue to learn from that data on an ongoing basis. And so I think a lot of folks find themselves logging on to ChatGPT, Gemini, or Claude and thinking, this is great that I can write a helpful email and bust out this reference letter in 2 minutes instead of 2 hours. Yeah, but is this really transforming my life? And I think the answer is no. We haven't seen those kind of more transformative use cases of AI. And I think a big reason for that is the fact that we haven't updated our laws to account for that. And in particular, we haven't updated our privacy laws to account for that. So I'm very much looking forward to this conversation and hopefully conversations on an ongoing basis that spark creativity so that we can begin to change our approach to privacy and data collection to unleash the more positive, transformative, and public facing uses of AI that we haven't seen yet.
Thank you, Pam.
Oh, hi. Thanks so much. Kevin, I love your comments. And first off, though, thank you for your kind invitation to bring me on to talk with all of you about this. I really appreciate it. It's great to see everyone here. So I just really want to follow on your comments, Kevin. And I agree completely that we don't have infrastructure yet. AI is not a new technology. It's been around for many, many decades now, and there's a lot we do understand about it. But as we're getting to more advanced forms of AI, there are changes. I actually co-authored a large report about this topic, parts of this topic, in 2023 with Kate Kay, our deputy director. It's called Risky Analysis. It's all about AI governance tools. And our basic argument there was, well, in regards to privacy, what is behind us is a huge history of privacy beginning in the 1970s, where we had decades of time to adjust to the technologies. But AI is really looking like it's a different kind of an animal. It's a bit of a zebra in that we're not quite sure what privacy is going to completely look like as AI gets its infrastructure developed. So to that point, I think something very important to consider is what I call protocols. I've spent a lot of time working on principles. I was part of the committee that created and helped draft and work through the OECD AI practices that are now really normative. And those were begun in 2017 and then finalized in 2019, updated in 2024. But the thing is that principles aren't enough. Law isn't going to touch all the things that we're talking about here. And I like the car analogy. I think it works. I'm going to add an analogy here, if I may. For me, the way I think about this is really at what I call a protocol level. And so if you recall when email was just starting, I do, there's a protocol called SMTP where you have to use SMT, or the systems themselves, the large systems or global systems have to use SMTP or some similar protocols so that the email can talk to each other. Very similar to HTTP and HTTPS on what used to be called the World Wide Web, now we just call online. So you have to have these very deep technical structural protocols so that systems can talk to each other. And that is what is in process with AI. We do have some AI protocols now, and they're being built right now. And I think this is a really important thing to think about, because this is actually where privacy is going to live. And laws and regulations may follow, but it's the protocols that really are going to create a lot of the new practices that will follow from how we learn about AI and how AI ends up interacting with systems and data and et cetera. So I'll leave it there and then join in the conversation as it develops. Thank you.
I want to echo my fellow panelists in thanking the Federalist Society and Regulatory Transparency Project for hosting this event. Thank you, Ashley, for moderating, and thank you to my co-panelists for some excellent remarks already. I took a couple of notes that I'm going to work into to what I'm going to respond to this question about. That I think you both already highlighted some excellent points. But before we do that, I do think it's important when we talk about data privacy to define more specifically what we are talking about, because privacy can be a very broad term. We talk about privacy as it relates to citizens' interactions with the government. We talk about privacy as it relates to consumers, and that can be either individual consumers or kind of business to business consumers, as it relates to privacy between many of the entities that we enjoy the products and services of. We talk about this both online and offline, and then oftentimes we see things like security or data breach get thrown in that. For today's conversation, I think Kevin and Pam and mine's all are planning to focus on that kind of second element where we're really talking about that consumer privacy interaction. How does AI interact with some of the ways that we as consumers or that businesses to businesses may be thinking about the data that they're using, the data that they're obtaining, what consent means like, and things like that. Kevin mentioned that in many ways this is like 1908 and the first Model T has rolled into town. I'm actually going to disagree a little bit there. I think this is more like a 1995 or 1996 moment where the internet has gained consumer popularity. AI has been around for quite a significant period of time. In fact, we've all actually been interacting with artificial intelligence in many ways for many years before things like generative AI, like ChatGPT, this kind of huge leap forward in consumer products integrating AI really became a more part of our daily lives just a couple of years ago. But AI itself isn't necessarily as novel as it's sometimes made out to be. And while it is a very disruptive technology, I think it's important to remember that our existing laws did not go away, and that can be both good and bad. So to kind of build off of the 1908 and the first Model T rolls into town example, we probably did already have some stop signs or some rules of the roads that were used to horse and carriage type of laws that could adapt to that new technology. But we also saw that there were some problematic laws, both in attempts to try and stop the technology. If you ever want an interesting read on this kind of interaction, I highly recommend reading about red flag laws where people literally had to run in front of cars so that they wouldn't scare the horses. But in many cases, the laws were able to adapt to this new technology without further intervention. What's somewhat unique with AI is that there are laws that may be able to provide guidance, but there are also laws that could be disruptive in negative ways, where we could see things that, like our data privacy norms, being challenged, or data privacy laws that can't adapt to new technology that could actually be more privacy sensitive at times. And this is because law is typically static while innovation is dynamic. And we've seen this with things like the GDPR in Europe when certain AI products initially tried to launch. There were a lot of concerns not around specifically were these privacy sensitive enough, but were they able to comply with the GDPR's specific requirements? So, in many cases, when we're talking about AI and privacy, I think it's forcing us to go back and ask some of those foundational questions in data privacy. Why do we value privacy? How do we value privacy versus other rights at times? What do we do when these things come into friction? And how do we create a situation where we're encouraging the good benefits of data usage, some of the amazing things that AI is going to be able to do, even with things that might be considered particularly sensitive, like financial or medical data, while at the same time ensuring that there is a response, that there is some form of recourse for consumers if they are harmed by malicious uses of data. If something does go wrong, what are their abilities to get some form of recourse in that situation? And how can we make sure that consumers are educated in a way where they're able to make actually meaningful consent-based decisions based on their individual privacy preferences? And I know there are a lot more things that I want us to talk about with what we're seeing going on at various state levels as well as at the international level. But I think that kind of gives an overview of how I've been thinking about this.
Thank you, Jennifer, and thank you for defining what we mean by privacy here, and that we really are focusing on data governance. I mean, those are two very different things. We're not focusing on government privacy or how one feels about one's privacy rights personally. And I'll ask the next panelist actually to define AI while we're at it. But moving on from that, I think it makes sense here to have a greater discussion about like the current laws. Like Jennifer said, sometimes they don't apply very well now. And it's kind of for one of two reasons. It's kind of, the problem of trying to fit a square peg in a round hole. They just don't work for AI, or there are concerns about it hindering the development of the technology. And like Kevin said, making it, useless for practical purposes. So Kevin, I'll turn it over to you next context to first talk about what AI specifically we're talking about, whether or not it's just algorithms or if it's generative AI or AGI, which no one seems to define consistently. But I think with generative AI, we have a lot more to go with here. And ask you does so our existing privacy law framework, or I would say frameworks, because we have multiple privacy laws, does it help or hinder AI development, and does it really still apply today?
Yeah, so in terms of defining AI, I don't think I have enough time to run through all the manifold different definitions that could be offered up here. Typically, when folks are talking about AI in a
What are
policy
we
making,
not talking about? I
yes,
guess.
yes. Typically, when folks are talking about AI in a policy making context, I think there are a couple key buckets that come up. One is commonly referred to as recommendation algorithms or engagement algorithms. Here, you're thinking of going onto Netflix and it's telling you the next show that you should watch, and that's as a result of both. Data that you've input, the shows you've watched previously, as well as sort of inferences that that algorithm is gleaning from your interactions and then recommending that next true crime series or reality show for you. In the same way, we see recommendation algorithms on social media platforms that are likewise using user generated information as well as other observations about your behavior to recommend certain content. Here, I think we're focused instead mainly on generative AI. This is the sort of new, but to Jennifer's point, somewhat new, depending on who you ask. Some people will point to 2017 as the real emergence of generative AI. Some folks will go even further, and some people will contest every date in between. But generative AI is more than just applying an algorithm to data that has been entered into a system. It's about creating outputs from that data. And in many ways, it's just a formal statistical process of looking at all of this training data, going through that training process to say, in which instances am I generating an output that I think aligns with how I've been trained or what goals have been set by my developer for what constitutes a good output. And so, in this way, the unique privacy aspects come from the fact that we need tons and tons of data going into these models to train them to output information that is actually useful, that's actually valuable to its specific use case. There's a lot of other models we could be talking about. New things that are popping up are world models, for example, that are particularly important for autonomous vehicles. There are specific multimodal models that are more focused on visual outputs, for example. Here, though, I think a lot of our focus is on generative AI and specifically large language models. And so, with that in mind, it's important to point out that a lot of our data laws, a lot of our privacy norms have evolved from the Fair Information Practice Principles, which were established in the 1970s. And so, as I hinted at back in my introduction, a lot of those Fair Information Practice Principles, or FIPS, are grounded in conceptions of privacy that just don't jive with AI. So, this may be things like being able to delete information, being able to access information, and really keeping information in a highly siloed bucket. So when we look at our federal privacy laws, we see laws like FERPA. FERPA is protecting the student data that's collected in all of our manifold schools across the country. We see laws like HIPAA that pertain to health information. We see laws like the GLPA pertaining to financial information and the Fair Credit Reporting Act, also dealing with a lot of financial information. And so all of these laws developed out of bespoke concerns about that specific niche of how data is being collected and how it's being used. Well, the really interesting part about AI is that it works best at spotting patterns that humans otherwise couldn't detect. It works best at diving into nuance and exploring new concepts that otherwise would have gone unexplored if it didn't have access to troves and troves of data. And yet, so long as we have laws like FERPA, HIPAA, the GLPA, I could go on, the Privacy Act of 1974, that are grounded in a sectoral approach, that are grounded in a siloed approach to data collection, then we're going to struggle with seeing the full benefits of AI apply. And that really came to a head in some of the conversations about how Doge, for example, was using AI to assist with its efforts to make government more effective and efficient. Where if we see, for example, that you're not able to access the whole span of data that the federal government may have on different agency budgets, for example, well, you may be missing the sort of interdependencies and patterns that could better identify ways to save money, better identify ways to help citizens access government services. All of these things are partially blocked by the fact that we have data that exists in silos. Well, of course, the reason we have data in silos isn't only because of those privacy concerns and data protection norms, but there are also considerations like cybersecurity issues. The more data you put in one centralized data set, that's a big honeypot that bad actors are going to want to go after. And so, how we navigate this tension of trying to get more and more data to further train and improve these AI systems versus recognizing the very real risks posed by that centralized data collection is a really wicked problem that we're going to have to sort out over time. But I don't think that our current framework really allows for that meaningful conversation. And so we need to take a more holistic approach of asking, what is it that we want from AI? Do we want it to really disrupt systems? Do we want it to really be used in its most transformative fashions? If so, then we need a holistic revision of some of those underlying principles.
Hey, thank you. Thank you for all that. That's very insightful on the federal level. Now let's turn a little bit to the states as well. I know there's a lot of debates regarding federal preemption and federal law and whether or not there should be a federal AI, more or less, as the media is calling it, a ban on federalism, as I saw one headline say, but something that would preempt this patchwork of state laws that would be a hindrance to the development of AI. Jennifer, could you touch a little bit on what's going on at the state level?
So a lot's going on at the state level. If we just look at AI focused bills, over 1,000 bills related to AI were introduced in the state legislative session in the last 6 months. So we are seeing a large amount of conversation around AI at a state level. And these, of course, vary from things like what we saw in Colorado. That's a quite comprehensive and, in my opinion, concerning regime where you could potentially have one state effectively regulating AI more generally because of requirements around either data usage or requirements around model size or things like that. There's another element, though, that as it relates to the role that states may have when it comes to AI, and that's what we've seen with the emerging state data privacy patchwork. So we're up to over 19 states that have some sort of comprehensive consumer data privacy law, all of which differ from one another slightly. And even if they were the same law, might have different interpretations when it comes to things like artificial intelligence's interaction with these state laws. So you have two really risky patchworks starting to emerge. And the reason that these patchworks, in my opinion, are potentially risky is that they cause confusion both for innovators, developers, as well as for deployers, so companies that may be looking to use AI in beneficial ways or to help their customers, and also for the individual users, the consumers whose data is being used. I'm based in the greater DC area, and if you live in an area like that, you know that it's quite possible that you could be, for example, on a Zoom call with one member in Virginia, one person in the district, and one person in Maryland, and all three of those would have different data privacy regimes. That's confusing enough in kind of the traditional internet era. When we start to get to a world where AI, which is so dependent on data, um, and data usage, is now having to also navigate that, it gets even more confusing. So while I often think there are a lot of things states can do to really be the kind of laboratories of democracy to provide, a good soil for innovation to really grow and flourish, when it comes to things like data privacy, like that kind of model level of regulation, we're really going to need a federal framework so that there's some degree of certainty for this innovation to flourish. That's also going to really be necessary when we start to see the interactions between US law and the laws that we're seeing, for example, in Europe, or for some of those developments, as Pam mentioned, of informal norms, of industry based regulation and kind of protocols over perhaps some of these regulations. If state laws are going to potentially require certain things that could make it difficult for a company to take a certain approach, that can be really disruptive or could result in one state not having the benefits that are available to other consumers.
Thank you for that, Jennifer. And so I'm going to turn to Pam now, just to kind of ask a broader, more general question about how we think about data protection practices and how that's kind of evolved as AI has evolved, or at least as it's become a lot more popular. And so from your perspective and your experience working particularly with both like those who are impacted by the regulations and the regulators, how has it changed the way that we kind of fundamentally think about data privacy practices?
Yeah. So, if I may, just
Mhm.
slightly redefine AI just a wee bit. I think it's really important to talk about generative AI and also large language models, but we really have to also talk about what I would call deep learning models, because that's a lot of the infrastructure of AI. We can't neglect it. That's more predictive analytics, not quite the same. It's a little more infrastructure oriented. So the data privacy question is quite complex in the United States in particular. It's actually complex everywhere, but there's more certainty in about 160 countries now because they have regulatory structures that are more harmonious with each other. They work across borders more easily. Kevin's correct. The sectoral structure that the US works in is very difficult in an era of AI. AI is difficult in regards to privacy practices, no matter what. But with a sectoral structure, it gets very, very difficult. FERPA, we have a very large report out about FERPA. We wrote it, let's see, it published right during the pandemic, as I recall. And it's everything you want to know about FERPA is in that report. It's called Without Consent. FERPA is almost, I mean, it's almost as if FERPA and some of the sectoral laws live in a different world than kind of where we are right now. So what I would say is that there are some parts of some of the sectoral laws that do apply, especially the Fair Credit Reporting Act, because the Fair Credit Reporting Act does regulate credit scoring, and credit scoring is a subset of AI, and it does work. There are certain parts of other laws that apply to biometric use. Biometrics are also a subset of AI, so that also applies. So you see these bits and pieces, so like a sub-regulatory patchwork, if you will, that applies to AI. I would also say that some of the state laws that have been passed around AI, the definitions of AI are really all over the place. Just definitionally, it's really difficult to find cohesiveness. And all of these things, I think, can be corrected over time. But right now, I think it'd be really tough to just wave a wand and say, let's pass this really giant AI regulation and we're going to get it right. I think we're in a really important transitional time. And I don't think that everything that that we want to be settled is going to be settled quickly. It's going to take time and experimentation. And let me give you a really good example of this. So the FDA has a lot of very important AI projects going on with medical devices. They have some practices and some protocols in place. And basically, you see a lot of scientists there working through how it works. So, for example, there's an amazing FDA study on medical devices and how AI fit. In other words, how well the algorithm fits the device, how the AI fit is working within patients. This is incredibly important, incredibly sensitive work. Is it privacy? Yeah, it is. But is it also quality assurance? Yes, it is. It's more complex now. The patient in this instance definitely has a privacy interest in that data. there's also a quality assurance interest in that data. There's also a broader public interest in that data, because if we can get algorithms within certain medical devices to have good fit and to have what's called good noise reduction, then we can have really great medical outcomes. So we have a lot of benefit. So how to balance all of these interests is really, really, really the heart of the question that we're looking at. And I think what's really important here is to be very patient with all stakeholders and to really hear from everyone and to try to get as much information as possible and be really fair about it. We need to hear from scientists about, certain contexts. We need to try to not be just completely broad in everything we're saying, but to really look for specific contexts and try to work those contexts and get those contexts right. There are some contexts which are much easier than others to get privacy right in. There are some really tricky contexts to get privacy right in. One of the trickiest that we're really looking at right now, certainly health is one, but another one is identity. Identity ecosystems are very sensitive. The United States does not have a national identity system like most of the rest of the world does. So, for example, a lot of the world has something called identity authorities that have a ministerial or cabinet level position to do nothing but adjudicate identity in that jurisdiction or country. We don't have something like that. We also don't have a system that is guided by a law that specifies how people can and cannot use identity. We have facsimiles of pieces of that. But for those countries with identity authorities and strong identity laws and strong comprehensive non-sectoral privacy laws, you're seeing these countries tackle the identity and privacy problem as a first and foremost problem. We're not doing that here. But if you really think about how AI works, we are coming up on a really big identity issue and in terms of privacy. How do we handle that? Well, it's going to depend on the context. So each of us in our contexts that we're working in, we need to really think about how do we solve the problem right in front of us. I think that we have quickly moved past the point where we could just launch a silver bullet piece of legislation into the stratosphere and say, okay, we just fixed AI with this. No, I don't think that we're there anymore. AI is too complex. It's too suffused into the deeper infrastructures and protocols, technical protocols. So we're going to have to really look at contexts, really get the use cases and work from that kind of basis. That's a personal opinion. I'm interested to hear other ideas, but that's where I think we're going, and I think that's where the rub will be. And I think through looking at various contexts, we'll develop what the new protocols will be specific to data privacy and data protection and data governance. There you go. Thank you.
Thank you for all that. And that raises some interesting points and some points that are probably best addressed by a different panel. But, you have all these other external policy interests that have nothing to do with privacy that, kind of lend itself to the ID problem, for example. So there are a lot of political pressures and other like overlapping policy issues that are totally outside of the privacy or AI sphere. So I'm going to kind of open up to the general panel, and so we can talk a little bit about like, if we were to start from the ground level, we didn't have any of the federal privacy laws now on the books or any of the state ones that are passing. What are some either kind of rules of the road or just like general considerations surrounding like where do we start? Let's take like data retention and deletion practices, for example. I think that would be a good place to start, as well as like the data maximization and minimization and localization. I think we should start with data.
Yeah, I'm happy to jump in here. I have a paper forthcoming in the regulatory review that I'll be sure to send out on the various socials, uh, theorizing about what it would look like if we could donate data like we donate blood. So in the same way that we really champion and celebrate people who share valuable information for the collective good, or excuse me, share their blood for the collective good, and bank that as a resource that can be used for people in myriad contexts. What if we could do that with data? I go run around Town Lake here in Austin and I record tons and tons of data on this Garmin watch. Garmin knows my heart rate, it knows when I run, it knows pretty much why I run, it knows everything about me. If I could share that information with, let's say, a public data bank, think of it like a blood bank, right? If I could share that information with a public data bank, that could then share that information with, let's say, nonprofits that want to analyze how we can better monitor public health for community residents, or with the city of Austin so that they can look at how we're going to re engineer certain traffic patterns or where we need to build out a new trail system. That would be incredibly valuable, not only for the residents of Austin, for myself, but also for future generations to be able to use this information in a way that's training some of this more public oriented use cases of AI. And what's frustrating to me about relying on the status quo is we've just all gotten pretty dang apathetic when it comes to our data sharing norms and practices. We give so much information to private stakeholders who don't necessarily have a direct benefit or a direct intention of redirecting that data towards something that is going to definitively and clearly help us. And so I really think we should start to consider what it would look like for a data donor model to develop, where you're seeing the sharing of information in a way that directly benefits you, your family members, and your community. I think that's one fruitful place to start. Another way to start is to really start investing more in basic AI research. So, something that we talked about in the prep call here that Jennifer pointed out, or excuse me, that Pam pointed out, is that there's really been some impressive technical jumps with respect to this idea of machine de-learning. So, how do you take information that the model has been trained on, and let's say that a consumer says, hey, actually, I'd like to opt out of the model being trained on my information. Well, as it stands right now, that's a very complex, very difficult technical challenge. If we can instead invest in some of this basic research into how AI is working, into interoperability, into that explainability of AI, well, then now we can actually craft privacy laws that are more responsive to when we think it is proper and when it may not be proper for AI models to train on certain data use cases. The issue right now of trying to put something into hard law, of rewriting privacy laws around AI, is that we may unintentionally set up AI for a certain technological path dependence. The laws we write right now could end up sending us in a unintended direction that forecloses us from realizing certain beneficial privacy practices or privacy norms among AI companies. One way to point that out is that in some of these state regulatory proposals, there is a limitation or a goal of, for example, preventing or only allowing explicitly neutral AI models, models that are free from any bias. Well, that sounds great in theory, but it may be that by virtue of experimenting with different models, we can find the model that's actually better at detecting bias, that's better at detecting instances of discrimination. And so now's the time to really pause, as you pointed out, Ashley, and think about this from a more holistic and future oriented perspective. And really, I think the emphasis should be on doing more technical research before we try to encapsulate new privacy laws.
I'm going to jump in with one of the panelists, one of the audience questions right here, just because it's kind of germane to this part of the discussion and going forward and relevant now. But when one of the attendees asked whether or not there are risks to Congress pursuing separate paths for both privacy, comprehensive privacy legislation, and comprehensive AI legislation at the same time, should the two efforts be combined, or should they be kept separately? Because otherwise, down the road, we can put the two paths on a collision course potentially.
I'm going to jump in if I may. In regards to the legislation, I think that whatever is done needs to be done based on empirical data, not on emotion. And it's really got to be factually based. And there should be use cases that are very specific that guide the legislation. And the legislation, whatever proposal is developed, needs to be tested in ground truth. It just can't be this written law that is not ground tested against what's actually happening in reality. And I think that that's just a really, really important thing to do. There are raging debates about whether or not to keep privacy legislation on its own or combine it with AI. I think I'm going to avoid wading into that because I see arguments on both sides. Um, yes, but if I may, I'd like to follow on with what Kevin was saying. You know, if you had to start with nothing as a framework, I think one of the things you'd really need to look at is the entire body of work around de-identification of data or reduction of identification of data. That is one of the impediments right now, is the propensity and the ability to pretty easily re-identify data sets in ways that are unexpected for individuals and also for groups of people. There are some really interesting National Institute of Health studies that came out in 2023 in regards to what's called collective privacy and what's called broad consent. Um, it's really, really difficult in certain contexts to be able to give consent for absolutely everything. So when that happens at scale, which it does in the AI context, what on earth do you do about consent? How does that begin to look and how does that begin to work? If you start to work on this as almost like a mathematical equation, you have to work through de-identification processes. You have to work through prohibitions on re-identification in certain contexts or for certain purposes. That's work that is really not really advanced enough for what we need in this particular deep learning, LLM, advanced era of AI, and it's just getting more and more advanced. So I think that's super important. Part B of what I would say here is that we've got to be really careful. When we're thinking about privacy, we need to remember that someone is going to adjudicate this privacy. There is going to be someone or some entity enforcing whatever law is created. So, how is privacy law at scale and at an AI speed going to be effectuated? That's a really big question that I don't hear a lot of people talking about. I really think that the best exemplar there really are some of the super large financial um, systems that are operating with literally petabytes of data, and they're doing so in real time, and they're also checking their systems in real time. And I think this is very, very helpful. You see this in anti-fraud systems, and you see this in additional systems that are operating across borders. This kind of instant checking is being done in other areas. It will have to also be done in the area of privacy, because it is going to be AI governance tools that are used to adjudicate privacy. It's not going to be people in beautiful suits and ties and dresses and, whatever in rooms. It's not going to be attorneys in rooms adjudicating privacy on a one-on-one basis or, like this. It's going to be digital systems, AI driven, adjudicating this at scale. So if you look at any major multinational corporation today, they're going to have some kind of tool that's looking at how their data flows are working and if they are complying with current privacy laws. This is how you see automated data breach notifications. It's how you find how companies can find various flaws in their own programs. These are not, they might be checked by hand, but really, when you're really looking at AI scale and speed, this is going to be very automated. So one of the big questions we have to answer in privacy going forward is, how will privacy be automated and how can we make it effective? And how can we be sure that the automation is working the way we want it to? So these are big questions.
I want to get back to the audience's original question with regards to the fact that we have an ongoing U.S. federal data privacy debate and we have an ongoing U.S. federal AI policy debate. And should these be the same debate or two separate debates? And I think it's the short answer is it's a bit of both, and it's complicated. These, like any almost any conversation these days, should be having a conversation about what the impact of AI is on the underlying law. A lot of the conversations around consumer data privacy have been based on the internet era, and as we said at the beginning, some of those presumptions have changed. Some of the ideas would be more difficult when we're talking about LLMs. When we're talking about the potential of deployment in certain industries or things like that, and that oftentimes we have a bit of a pacing problem that can be also a pacing benefit. Sometimes if we allow the technology to evolve, we will see where are those areas that we actually need clarity and response versus where are those things that we were concerned about them 6 months ago that we've actually found that social norms or innovation itself are better suited to solve, or that our existing laws already cover. Likewise, there are likely to be times where there needs to be a bit of a deregulatory conversation. Are there things in existing privacy laws that, in some of those sectoral specific laws, as Kevin mentioned, that make it more difficult to use, for example, AI tools in cybersecurity, or AI tools that could actually be more anonymizing of the data than was previously seen. So I think these two conversations don't exist in a vacuum, but I don't think that's unique just to AI and privacy at this point. I testified last week in the House Financial Services Committee subcommittee on financial institutions around data privacy in the financial institution sector, and this is one of the conversations that certainly came up is how does this data that's traditionally been regulated potentially potentially interplay with existing laws like GLBA? What impact does this have, particularly on small businesses? And I think this is going to be something that we see many other committees that have traditionally had these sectoral data privacy laws grappling with. At the same time, it's likely in the context of AI and AI policy that many of the concerns that consumers have or that policymakers have are related to their concerns about privacy. Where is the data being used coming from? Has there been meaningful consent? What does this mean in terms of some of the practices around AI? So that I think that there is likely to be a privacy conversation within the AI conversation as well. And so I think that of course these two proposals, if we see them, or however these policy conversations evolve, will certainly interact. I think when we think about the US's current approach to data privacy, there have been a lot of statements around these sectoral laws already about their applicability in the AI context, whether it's from the agency administering them or beyond. And I think there will also be kind of continuing questions around whether or not these existing authorities are sufficient if there are concerns that arise over AI.
I'm gonna ask another broader kind of question. We've been talking a lot about sectoral concerns in state versus federal, but what about the privacy laws that, I mean, well, not privacy laws, but laws that other agencies that are not sectoral, but are kind of broader and behavioral based, such as, the Federal Trade Commission and, unfair deceptive acts and practices and, things such as like legitimate fraud and spam and that sort of thing. Like, where do those pieces fit into the puzzle here, and where do you see that going?
Yeah, I think one really important thing to flag about some of our unfair and deceptive acts or practices statutes that exist at the federal level and at the state level is there's no AI exception. Those laws apply to any technology, and AI is included. And so when you think about AI companies, for example, that may be misrepresenting what data they're collecting, or when you think about AI companies that may be using some nefarious practices to try to hoover up more information about you than you intended, those are still subject to potential litigation under state UDAPs and the FTC in many contexts. And so we've already seen, for example, here in Texas, our AG has been on the edge of applying the state's UDAP to some of these egregious practices that AI companies have been using to perhaps misrepresent just how sophisticated their AI tools may be, as well as what information these AI tools are using. And at the FTC level as well, we know that Chair Ferguson is very attentive to the fact that we've seen historically big tech companies use their size, use their network effects to perhaps embrace some sketchy privacy practices that would otherwise not have been allowed if they were a smaller company or didn't have the sort of corporate power that they're able to use. So I think when we look at these broader consumer protection statutes, it's important to realize that they're still very effective and they're being used already in the states and at the federal level to help protect consumers. And so I'd encourage people to pay attention to how those various enforcement actions evolve over time, and also encourage folks to start sharing when they feel like an AI lab might be acting in a way that doesn't align with their expectations. One example that I'd particularly like folks to be aware of as we enter and can continue to progress in the so-called Year of Agents 2025, a lot of companies, including OpenAI, including Google, and soon including Anthropic, are developing AI models with better and better memory and better retention of your prompts. So you will be able to either directly ask a model to retain certain information about you, or that model just might start inferring and saving information about you. And so we need to get out in front of thinking through from a consumer's perspective, what are the norms? What are the standards we want companies to adhere to when it comes to knowing just about everything about you? And not only knowing what information you've entered into that model, but then critically inferring things about you that it will retain over time and bake into its outputs over time.
So I want to jump in here on kind of the existing agency point. I think that, I echo Kevin in that in many cases existing, if you're committing fraud, we already have laws around fraud, whether that is your AI is being used um, to facilitate the fraud, then the bad actor using the AI probably is not exempt from that. If it's fraudulent claims about the AI itself and what it can do, again, in many cases, we have existing laws that would cover that. However, the caution I would issue there is we have seen at times agencies try and take the fact that they have authority over some element and expand that to be a much broader authority around a technology like AI or something like that. And I would caution the agencies or caution states to think very carefully about that, particularly in light of many of the things that I know we've discussed on regulatory transparency webinars in the past around potential agency overreach, around non-delegation doctrine, around the deference that may or may not be due agencies in a post-Loper Bright world, that an agency shouldn't just wake up one morning and decide that it is the regulator of AI. That being said, we have seen agencies take proactive steps at times in positive ways. An example I can think of as well that doesn't often get as thought about in the AI context are questions around driverless cars, and that as an application of AI, where we've seen the Department of Transportation having these conversations for a decade or so now, and that there probably will be privacy conversations related to that as well. What is your car? What data can your car use? How can that be shared or not shared with an insurance company, or with the government, or things like that? And so we certainly will continue to see AI actions at agencies. I would just caution that before an agency wakes up one morning and decides that it is our federal or an individual state's AI regulator, that it remembers how delegation works.
I think what I would say to this issue is that it's really important to remember that we're in a transitional time with AI. Some laws will still apply, and it's really important to articulate what those laws are. Certainly the Unfair and Deceptive Acts and Practices, FTC Act Section 5, these still have huge applicability to different aspects of AI. But if you really think about AI, not as a thing unto itself, but as part of the plumbing of our infrastructures. I think that will really help, because that's really what we're looking at happening within the next 5 years or so, maybe sooner. So it's really a very, very deep digital public infrastructure. And because of that, it makes it very difficult to say, well, one particular law will apply to all of AI. I think we're really looking at a situation where we have to look at context very carefully, not necessarily sectors, maybe sectors. It's going to depend on how this works out and on how the conversations go on this. I can't predict that, but what I can say is that yes, right now there are definitely statutes that apply, and there are many that do. It applies to pieces here and there and to use cases here and there. So we're really seeing an incredible time of chaos and transition. And it's going to be bumpy for a while until things settle down, until the digital public infrastructure is fully built out and the networks start talking to each other harmoniously. But in the meantime, I think it's really important, again, to go back to the technical research, the scientific research, the policy research, looking at what user experiences are, and really basing whatever happens, whatever conversations we have, with multiple stakeholders and with ground truth reality, not just opinions. It's just super important that we get this right.
Anything else to briefly add? We have 4 minutes here. If that covers it, I can ask some fun questions. What are your favorite or least favorite AI tools? What's useful that you've found out there?
I'm going to jump in first here. I think one of the real dangers with some of the AI tools, and I'm thinking of governance tools right now, but one of the real dangers is when you take a tool that was created for one purpose and start using it for all sorts of other purposes. So for example, Lyme and SHAP algorithms were made for very specific purposes, and they're being built into so many ML DevOps systems and AI governance tools as like this thing that will test for fairness across all sorts of contexts where they were never intended to. And we really, when we're using AI tools, we've got to have metrology in mind. We need to, if we're going to use an AI tool, we need to have a system that says, okay, this is a high quality tool or not. We've got to figure out how good the tools are and be able to adjudicate and test those tools themselves. We need some fail safes in the actual tools. So yes, AI tools, yes, testing of the AI tool to make sure that what we're using is effective and fit for purpose and the purposes that we intended it for. Thanks.
I was going to give some what I think are really fun ones. I appreciate Pam's very serious answer, because I think it's also important to remember what some of the everyday benefits that we're experiencing with AI may be. If, for example, the fact that many airlines now are using AI if you're at risk of missing a connection to help identify and rebook you on a flight, or to let you know, and even hold planes. And sometimes if there are several individuals rushing to make a flight. I know people who've had problems with this technology as well. I'm not saying it's perfect, but it's an example of how a set of data is being used to benefit a lot of individuals in a potentially stressful situation. I think one of the cool features we've seen people doing is using ChatGPT, for example, to take a picture of what's in your fridge and have it give you suggestions of what recipes you could make for dinner. I think a lot of people find that to be helpful, and particularly if you're someone who may be trying to meet specific dietary requirements or trying to deal with some sort of limited resources, that can be hugely beneficial. And then, we've seen some really cool things around, for example, being able to do more virtual try-ons that are truly personalized when you want to see how an item looks in a room, or how a piece of clothing looks on you before you order it. Being able to do that from a comfort of your home in ways that actually let you get a better idea. It may not be as perfect as going to the store, but is the type of thing that I think many individuals have had that experience of ordering three different things and then having to send ones back or not being sure what it will look like when it's not on the model or not in the showroom, and really having that kind of opportunity to just better understand the purchases you're making.
And I'll just add very briefly two things. So number one, just my favorite line ever. If I can leave anyone with one piece of advice or one note, this is the worst AI we will ever use. AI is only going to get better. The issues we're experiencing will decrease over time. So just keep that in mind. And for those who want to have a little bit of fun, especially given that we are approaching a celebration of 1776, I wrote up a prompt that folks should check out on my Substack, Appleseed AI. You can just enter in a historical document and it will spit out a translation of that for whatever audience you're intending. So today I broke down the Declaration of Independence for fifth graders. And among my favorite lines is, "The king has been mean." So check that out if you want to have a little bit of fun of breaking down everything from the Northwest Ordinance to any other fun historical document.
And I actually recently asked Google Gemini to summarize Wickard v. Filburn in the tone of a Trump social media post, and that was pretty fantastic too. Not a productive use of those. So with that, we're approaching the 1 o'clock hour. So I want to thank all of our panelists and thank you to the Federalist Society for hosting us today for what was a really great conversation. I feel like we couldn't, we couldn't cover all of this in a day if we tried, but we did a pretty good job with the hour that we had.
Wonderful. Thank you so much, Ashley, for moderating. And thank you again to everyone on our panel for joining us and for sharing your insights today. Thank you also to our audience for tuning in and for your excellent questions. For more content like this from the Regulatory Transparency Project here at the Federalist Society, discussing the regulatory state and the American way of life, please visit us at regproject.org. That is REG, regproject.org. Thank you.